The topic of today, as I said, is penalties against women seeking international protection. The reason we decided to look at this topic is because in addition to the obstacles faced by refugee women in obtaining refugee status in the first place, states across the world also increasingly use various mechanisms designed to limit access to long-term protection. And in parallel, women's citizenship is at risk in many regions of the world, meaning that their access to protection by the state is increasingly under challenge. In this seminar, we hope to explore how refugee women experience penalisation through mechanisms such as cessation of refugee status, or the denial of citizenship through the denial of naturalization, and also how statelessness impacts on women in particular. Today, we will hear from Natasha, YACOUB, Paula Banerjee, and Catherine Briddick. Thank you so much to all three of you for joining us today and sharing your expertise on these important topics. Our first speaker is Natasha, YACOUB. Natasha is an international refugee law practitioner and scholar who worked for UNHCR over 2 decades. Natasha teaches international refugee law at the University of London, where she also chairs the very important working group on feminist theory and refugee law. Natasha will talk to us today about cessation of refugee status and its impact on women.
Thank you for inviting me to speak today with, I have to say, so many brilliant scholars whose work I rely on and at all times and consider myself to be lucky to be part of. So I will talk today about ceased circumstances, cessation clauses. And the reason I like to talk about ceased circumstances of refugee status is because unlike refugee status determination, both the substantive and procedural aspects, cessation, so where the beginning of refugee status, if you like, is often discussed from a gender lens or a feminist perspective. The end of refugee status is not, so where a cessation applies, and where we're talking about the law punishing women in a cold climate. I would say that the application of cessation as a punishment for women is not unfortunately new, where gender is invisible in the law. So that will be my my argument today, I guess, is just this is the law as it applies to ending refugee status. It's as often as important as when it begins, and yet very much understudied and therefore can very much be used by states as another tool to in a very large toolbox of laws that can be applied to punish women or rather than protect women. So although I should also say that I will not end on that depressing note, and I'll talk about what is cessation and give you a brief overview of the law and the criteria for applying cessation, and then in the first part, and then sort of look at how it's applied by states to silence women and ignore their experiences, and then I'll end with an example of a dynamic interpretation of cessation where that silencing of women and punishment of women, if you like, can be addressed by applying a human rights law lens to interpret refugee law. So on to the introduction then. I probably don't need to tell you or explain to anybody here how cessation is applied to end refugee status, because it's often in the media when states decide, and often UNHCR with states, decide to cease refugee status either on an individual or a group prima facie basis. ignoring the needs of refugee women and thereby planning for a return to the country or return to the protection, what should be returned to the protection of their country of origin. Countries like Afghanistan and Myanmar and Sudan, where in recent years, asylum countries have agreed to apply cessation to return women in large numbers, have, as you know, completely disregarded the dire or increasingly dire situation for women there. In the case of Afghans returning to Pakistan, Human Rights Watch documented very clearly that women were returning to a situation that was so dire that at the same time, countries in Europe were offering prima facie refugee status as a group. So it's that clear that where one group of states are considering it so unsafe for women to return that as a group, they would be getting refugee status. On the other hand, cessation is being applied to the same group of women to say that it is safe to return. So it's very, very, while it might not be now, it's definitely in the process for women in Sudan and Myanmar as well. And looking back historically from the 1990s, when it's been applied on a group basis in Rwanda and in Eastern Europe, the situation has not been different. So unfortunately, it's sort of a new situation. I just want to say that cessation, of course, can be for voluntary reasons, but I'm just only talking about involuntary situation where the situation itself in the country of origin is considered by the asylum state to have or the reasons for causing refugee status have ceased, such that it's safe to return. It's not a durable solution. It shouldn't be conflated with voluntary repatriation, but often is conflated. Cessation of refugee status is a very separate process to a solution, because even where refugee status ends, the solution for women, the appropriate solution, may not be return. But notwithstanding that, it often is conflated, as you know, in large-scale agreements for return. I will move on just very quickly to part one, where I'll explain what the criteria for cessation of refugee status for ceased circumstances are, or the ceased circumstances cessation clause. So you'll find them in you'll find the ceased circumstances clause in Articles 1C5 and 1C6 of the 1951 UN Convention relating to the status of refugees. It's also in the OAU Convention, in regional laws like the OAU Convention and the Bangkok Principles, the African Asian Legal Consultative Organization. Bangkok Principles, although non-binding, also contains similar provisions. Although the OAU Convention and Bangkok Principles also mention sex or gender, where the 1951 Refugee Convention does not, I would like to focus on the 1951 Refugee Convention because it's most often applied by states, whereas the others are not. So what does the 1951 Convention say? Basically, so 1C5 relates to refugees with a nationality, and 1C6 applies to stateless persons. But the text, the substantive text for cessation is the same. So it applies where a person can no longer, because of the situation that caused their refugee situation, the recognition as a refugee has ceased to exist. So they can no longer refuse to avail themselves of the protection of their country of nationality or former habitual residence. So that's the substantive clause for ceasing refugee status. And then there is a provision of exceptions where for persons who invoke compelling reasons arising out of previous persecution, they're refusing to avail themselves. There's an exception for those people. And states very rarely apply that exception, but it's an important protection. And looking at the drafting of the Refugee Convention, the 1951 Refugee Convention, Travaux, we'll see also that that was an important, or envisaged as an important protection for women. So I'll talk a little bit more now about how states have interpreted the law. Oh, firstly, I just wanted to briefly mention, yeah, it's fine to flick to the next one, but for me, I think it's important also to see refugee law, of course, in the context here of principles of general international law. So it's impossible to look at cessation of refugee status without looking at the responsibilities owed by sovereign states to their citizens, whether they're nationals or stateless persons. And that's sort of the idea from Nottenbaum that where states have responsibilities towards their own citizens, these can then be taken into account in assessing what levels of protection are owed to people whose refugees status ceases. And then also, of course, because cessation of refugee status in the asylum country would have an impact on other countries depending on solutions, then the principle of international cooperation is also relevant. And I've written quite a lot about the importance of general principles of international refugee law in an Oxford handbook on women and international law recently. It's coming out, I think, this month. I feel that's really important to ground it in these principles, to understand it and apply it to protect women. Of course, mention international human rights law. As you may know from your own country context, it's applied in a very confused way. It's applied in a very it's underdeveloped, and certainly in a way that makes gender considerations invisible. For as long as the law is confused and the legal criteria are so confused, then the obfuscation of women's needs is similarly very, very easily trumped, to pardon a pun, by states' interests, and that's certainly what happens with cessation of refugee status. So, what ought to be the legal criteria, I argue, and I have a RLI blog on this, but haven't published a larger piece on it. Is it first, there are four criteria, I would argue, and the first is a change in the situation in the country of origin that is fundamental, stable, and durable. So that's a group determination. That's how is the situation for women in Afghanistan now? Is there, could one say that the reasons causing flight have ceased to exist? So that's on a group basis and ought to take into account women's needs. But in the case of the cessation of refugee status in Afghanistan, as you know, very often does not, and certainly does not take into account private harms faced by women. The second is the removal of the threat of persecution causing flight on an individual basis. And that's been subject to different interpretations by court, that it's a mirror of the refugee definition. So whatever caused flight in the first place should be removed, or secondly, that there's a need for the removal of persecution plus adequate protection. So a more generous interpretation, if you like, or effective protection should be granted. And there's some excellent literature arguing that the more generous approach should be adopted, and UNHCR also adopts a more generous interpretation of that provision. And then finally, of course, once if cessation is applied either on an individual or a group basis, the compelling reasons exception should be invoked. And I would say that even though and there's no data on the application of cessation country by country, there's really a dearth in the data that's held by states, and there's a dearth even of academic and human rights reporting on each country's application. What we can say is that even where the cessation is applied on a group basis, it must of course entail an individual determination if the compelling circumstances exception is to be applied. But of course, we know that very often it's not. I'm just going to skip quickly through parts 2 and 3 now. So I think I've drawn the case. It's very confused. The application, the criteria themselves are confused, but I've also explained that that gender is completely missing. One of the key concerns with that is that the women do not participate meaningfully, either not just in an individual basis, but also on in the group determinations, where states and UNHCR often sit at the table to make determinations of decisions concerning cessation, but women themselves, of course, are not at the table. And the OAU and other regional bodies have really envisaged that refugee women would have a seat at the table in some of their draft proposals. I think I had proposed, and you'll have to wait to read an article on that when it finally comes out. But I draw on a lot of the work of people here, so I don't need to tell you what I do because you do it. It's Christelle's work. It's in fact all of you, I think, here would one way or another look at human rights law to interpret the criteria of refugee law that ignore women. So I'm not going to go through a dynamic interpretation of cessation. It's done in the blog. So what I will do though is conclude to say that although cessation of refugee status as it's currently applied by states can act as a punishment for women, can cease their refugee status based on the interests alone of powerful states, whether that is the asylum country who no longer wishes to host them or desires or feels able to host them, or the country of origin that wishes to legitimize a change and show that return is possible. They're prioritized over the humanitarian protection of women or considerations on needs of women. But with the feminist approaches to cessation, that does not need to be the case. And I would urge then for a feminist approach to cessation going forward to avoid protection of women through the end of refugee status and instead ensure their ongoing protection through cessation. Thank you.
Thank you so much, Natasha, for this very brief but important overview of all the different elements and how we can interpret it in a way that takes into account the particular needs of women. Now I'll introduce our second speaker, who is Paula Banerjee. Paula is a prolific scholar and author, particularly known for her work on women in borderlands and forced migrations in South and Southeast Asia. At present, she is the International Development Research Center Endowed Chair on Gender and Forced Displacement, and also the Director of the Center on Gender and Forced Displacement at the Asian Institute of Technology. She's the editor of Refugee Watch and the editorial board member of a number of international journals, including the well-known Journal of Refugee Studies published by Oxford University. Paula will now be speaking to us on statelessness and its impact on women. So over to you, Paula. Thank you.
Thank you so much, Crystal, Nicola, Moira, all of you. I think this is an amazing array of speakers, and I'm so proud to be part of this panel. I am actually going to talk about the maximum penalties that are there for women seeking asylum. I'm going to talk about a group called the stateless people. Now, to begin with, it's a very problematic thing to call anyone stateless, because what it means is you cannot get or you cannot claim nationality from any particular country. Now, to get benefits of statelessness, these people have to be declared stateless. Countries can always say that they're not my citizen, but how can countries have the power to say that a person is stateless? Therein lies the first problem, but that's first of many. And then, the world knows that UNHCR says that there are 4.4 million stateless people in the world, but the number is way, way more than that. And the maximum number of stateless people, according to most scholars and also UNHCR data, is that they are from the Asia Pacific, largely from the Asia part. And that is why I am at an advantage, because I am in the belly of the beast. I'm speaking from the belly of the beast. There are multiple reasons why people become stateless. Most of us know the reasons. If a country's border shifts, as it did after the fall of the Soviet Union, or if there are discriminatory laws. Now, these discriminatory laws are made with intention. They are not laws that just happen. For example, in Myanmar in 1982, the Rohingyas were deprived of nationality or citizenship in the case of Myanmar. Now, if today we say that that just happened, then we will be completely wrong. Most people become stateless, and I'm convinced about it through my research, because of intent. There are groups of people who do not want you to acquire the advantages of citizenship. And the sad thing is, the international system in the world today is based on rights accrued to citizenship. So the most basic right as a human being is the right to life. But even that life is something which is in contention for stateless people. If you do just a simple Google search and say that, reasons for statelessness, you will get multiple reasons, like deprivation from, your citizenship right, or conflict might be a cause. Then one cause is never highlighted. One is the loss of land. Like during tsunami, there were islands that disappeared, and people who lived there, when they went to other places, they became stateless. So, there are multiple causes you will get. There are multiple causes you will not get. But the most heinous problem or effect of people living as stateless is that they are deprived of their rights, most of their rights, political rights largely, but also other kinds of rights, because we have just got over, if I might say so, from COVID. And we know that the basic right to life was challenged for stateless people. They did not get any kind of health care. And today I'm asked to talk about women. Now, women, particularly among the group of people who are stateless, are in the greatest of problematic situation. Firstly, statelessness happens because you as a group are less powerful. You as a group lack power. If you are a powerful group, you will not be stateless, take it from me. Very seldom you will be stateless. And among that group of people who are already very, very less powerful, I will not say, because we are all now geared into capillaries of power and Foucauldian logic. So it's very, very difficult to say that people are completely powerless. But if there are people in the world who are completely powerless, then it is stateless women. Primarily because these women are treated as non-legal entities everywhere. But stateless people have a position from the 1954 convention to the 61. They have a legal position. I first confronted, and I see my student and my co-author here among the participants, I first confronted stateless women when I was doing a research in the border jails of India, looking at Bangladeshi women who were caught by the 1946 Foreigners Act. There, the welfare officers told us there are a group of women here who were given a prison term of 2 years, but after that, we cannot send them back because we don't know who they are. They're not being able to tell us. We don't know their language. We don't know what papers they possess, where they want to go. We have absolutely no idea. So we were some of the first people to trace Rohingya women in the Indian jails. And these women who had served their prison terms could not be sent back because they are stateless. They have no place where they belong. So when we say that a stateless can become a refugee, that would be the lucky few. Because the unlucky ones perish in the state where they are habitual residents and where they have absolutely no rights. There are thousands of stateless Cambodians. During the time of Khmer Rouge, they went to Vietnam. I mean, leave alone Rohingyas. There are millions of Rohingyas in South and Southeast Asia. In Bangladesh alone, people say they are 1.5 million. But I'm not talking about the registered people who are in Kutupalang camps or some of those camps. I'm talking about those living in Leda. Now, the interesting thing is these women face enormous gender-based violence. We have seen how much gender-based violence climbed up in our statistics during COVID. But stateless women face that every day. They face it from the authorities. More importantly, they also face it at home. Their work of caregiving never ends. Their work of feeding their children never ends. Yet there are countries even today in Asia. I don't know so much about Africa, but I think there might be one or two countries, even in Africa, where women cannot pass their citizenship to their children. So imagine if a child has a stateless father and a mother who is a citizen of Brunei or some such country, they will not be able to transfer their citizenship to the children. The children will grow up as stateless. Stateless women also face enormous, vulnerability where trafficking is concerned, because the entire umbrella of protection is based on your citizenship rights. The countries that have forced you to become stateless, the international regime looks upon those countries to provide you with facilities so that you are saved from statelessness. What can they do? They just write conventions like the 61 Convention, how to reduce statelessness. But in actual fact, that is not a solution because the countries have made you stateless. So how can we look at countries to give you back that protection that you deserve as an individual, as a living being, human beings? Women all over the world, face structural violence. And this situation of statelessness is a result of vulnerabilities growing out of different situations. So, statelessness, if it is an affliction of the more vulnerable people, then the women among them are the most vulnerable. Yes, if we consider LGBTQ communities, probably they're equally vulnerable. And if we look at the issue of gender, I am not saying masculinities or stereotyping of masculinities is not responsible for creation of vulnerabilities. But my concern here are the women, because certain groups of men can be vulnerable, certain groups of white people can be vulnerable, but mostly women, colored, living in the global south are the most vulnerable. And that is why among the stateless population, they are the most important group. When in 2015, there was 1 million refugees trying to get into Europe, it became a crisis. Before that, it was not considered a crisis. So the New York Declaration, 2016, after that, we have the global compacts. But the interesting thing is Asia and Africa is facing millions and millions of refugees. In my country, 15 million refugees happened in 1947. It was not considered a crisis. So there is a politics here that we have to be very, very aware of. We cannot close our eyes and say that statelessness is an affliction because borders are moving. Borders might move, but the Adanis, the Ambanis, the rich people of the world are not affected by borders moving. They move the borders with themselves. But the poor, the women, the infirm, the physically differently abled people, they are the people who get afflicted as a result of that. Today, we are in the process of trying to say that there is something called de jure stateless and the de facto stateless. But what is the difference? The legal status, of course, is an advantage, but the de facto are the people who are even more problematic as a group because they suffer all the afflictions of statelessness, yet they do not have the legal provisions to support them. Crystal, how am I doing for time?
You have 1 minute left, Paula. Is that okay?
1 minute? 1
One.
minute? Okay, lovely. I will end with one thing, and that is look at, something that I'm very, very proud of. It's a flawed mechanism, but it's the UN Resolution 1325. This was one of the first proactive resolutions for us. We all fought for it, and we were active supporting it. But look at how many times it mentions statelessness. Then you will know the real problem behind statelessness. Neither the activists working on refugees, nor the feminists, nor the activists working on women's security ever make statelessness its rallying point. So it's high time that we recognize that the Janus face of a citizen is not a refugee, but it is a stateless woman, the most abjectly poor, the least, people with the least amount of right, but not without courage. stateless women like the Rohingya women show enormous amount of courage, and the story of courage is something that I can tell you another day. Thank you so much.
Thank you so much, Paula. And you really highlighted the scale of the problem. You've done that really effectively, and perhaps in the questions we can, in the discussion at the end, we can talk a bit more about what you think are appropriate solutions, because we hear your criticism of the existing system of international law. Thank you. So we're now going to move on to Catherine, last but not least, Catherine Briddick, who is a scholar of human rights and refugee law and barrister, although currently non-practicing. Catherine is an associate professor of international human rights and refugee law at Oxford University and a fellow of St. Anthony's College. Catherine is a member of the editorial board of the International Journal of Refugee Law, and she's also on the board of trustees of Women for Refugee Women, who's a fantastic NGO based in the UK. Catherine is a research associate at the Refugee Law Initiative and an associate fellow of the Higher Education Academy. Today, Catherine, you will speak to us about the duty to facilitate naturalization and the particular challenges facing refugee women in this respect. Over to you, Catherine. Thank you.
Thank you, Christelle, and thank you to all of Women in Refugee Law for organising yet another brilliant event. Some other thank yous to Dr. YACOUB and Professor Banerjee for setting up my contribution on the importance of routes to citizenship and naturalisation so spectacularly well. And also thank you to the co-authors of a report, the research for which I'm going to be drawing on in part today, Professor Catherine Costello and Minos Mouzarakis. I'll give you the references at the end so you can see some of the materials I'm drawing on. So I'm going to be talking about the duty to facilitate naturalisation. And I'm going to do so by talking first off about its place in the Refugee Convention and what's called the structure of entitlement of the Refugee Convention. Now, many of you know that when you interpret an international treaty, there are particular rules of treaty interpretation. So according to the Vienna Convention on the Law of Treaties, international treaties like the Refugee Convention or the Statelessness Conventions have to be interpreted in good faith in the light of their object and purpose. Now, status matters are at the heart of the Refugee Convention. We know that because of the title, so it's the convention relating to the status of refugees. We know it because of the preamble, which refers to the greatest possible of enjoyment of rights without discrimination and the ability to exercise the widest possible extent of the broad array of fundamental rights and freedoms provided by international human rights law. And we also know it because of the constitutive nature of refugeehood. What I mean by that is that a person is a refugee at the point of time that they meet the refugee definition. So the convention sets up a system where rights are recognized through the granting of a rights protective status, which will be called refugee status in many jurisdictions of the world. But whether or not you are formally recognized by a state, you are a refugee if you meet the Article 1A2 Convention criteria, and you have the rights that go with recognition until the point at which you reach a durable solution or the end of refugee protection. Now, during this period, the time at which you're covered by the convention and the rights and freedoms that I've mentioned that it bestows, your rights incrementally increase over time. So initially, somebody who makes a claim for refugee protection in a state is protected from refoulement, from a situation where they may face return to a situation where their life or freedom would be threatened. But over time, as their connection with the new country of origin or with the host state or the state of asylum increases, they accrue a broader range of rights and protections, initially in comparison with other non-nationals, but reaching the point where they should have their naturalization facilitated. So I want to come back to the point that Dr. YACOUB made about solutions and the difference between cessation and solutions. So UNHCR statute distinguishes between international protection, which is recognizing someone as a refugee and the rights and protections that go with it on the one hand, and permanent solutions on the other. And permanent solutions, as Natasha has said, is voluntary repatriation as one potential solution, resettlement, or, to draw on the language of UNHCR statute, assimilation within a new national community on the other. So the Refugee Convention itself does not regulate solutions, but what it does is create a rights protective legal framework which enables them. So cessation is the process by which refugee protection comes to an end. Assimilation, which is the language used in UNHCR statute and the Refugee Convention itself, is a reference to this structure of entitlement that I mentioned before. The idea that over time you are able to access a broader range of rights, economic and social rights, right to education, for example, the ability to work, to housing, ending in this naturalization. Just a kind of word on naturalization and assimilation. Now, when we think about the word assimilation, many of us think of it in terms of a denial of people's diversity, for example, or a denial of refugees' identity and distinctiveness. That's not how it was used at the time. So it's very much a product of the drafting period. Assimilation here isn't saying that everybody has to be the same or behave in the same way, or that diversity is something to be denied. It's saying that over time that the refugee becomes a member of the host state. So what I hope to have done very briefly is to give you a sense of how the Refugee Convention should be interpreted. So in good faith, in the light of its objects and purposes, of which non-discrimination is one. To give you a sense of why status is at the heart of the convention, and to give you a sense that what the convention does is create this framework whereby naturalization is in effect the default pathway for refugees. So firstly, the recognition of a person as having a well-founded fear of persecution, over time accruing greater rights, leading to naturalization, full membership of the host state. So the particular provision that deals with this is Article 34 of the Convention. And this is what's called an obligation of conduct. What I mean by that is that Article 34 doesn't require states to naturalize refugees. So that's not the outcome of Article 34. And there are a number of good reasons for that. So at the time that the convention was drafted, and even in the world today, there are a number of states that don't allow people to be dual nationals. And there was a concern that requiring states, for example, to naturalize could place an undue burden on states of asylum. But it could also preclude other options for refugees in the future who might want to acquire other types of citizenship. And actually, the convention, and I haven't kind of gone into detail about this, but at all points tries to facilitate the choice of the refugee. So Natasha mentioned in her talk about cessation that she was dealing with only the C circumstances clause, but the weight of the cessation clause itself is focusing on voluntary action that the refugee themselves take to bring their refugeehood to an end. So again, the structure of entitlement of the convention is rights that increase over time, but rights that the refugee exercises meaningful choice over, that the refugee chooses when and how, for example, status comes to an end, and then when and how they return to their country of origin, if they feel that that's the right choice for them and their families. So Article 34 doesn't require states to give membership of the new political community. It has two elements to it. So one, the facilitation of assimilation, and two, the facilitation of naturalization. So this is what I mean by an obligation of conduct, and it's a very strong obligation of conduct because states have to, as far as possible, facilitate both of those things. So when we see other kind of obligations of conduct in international human rights law, we see things like states shall take reasonable steps to, or states can do as much as possible to enable. And these are good obligations of conduct, but what's really interesting is how high the drafters of the convention pitch this particular obligation. So as far as possible, facilitate the assimilation and naturalization of refugees. And then they give two examples, the drafters, of what this would look like. And it's making every effort to expedite naturalization proceedings and to reduce as far as possible the charges and costs of such proceedings. So it's a demanding standard. It requires states to take positive action. So doing nothing isn't an option under Article 34. The two examples given in relation to expediting naturalization are illustrative, they're not exhaustive. So these are just examples of things that states should do, but they may need to take other steps to facilitate naturalization. Crucially, however, any barrier to securing citizenship has to be justified in the light of this strong obligation of conduct. And new barriers in particular, so when states make it harder for refugees to acquire citizenship, will require justification. Because if something was possible in the past, how can a more restrictive change be doing as much as the state is required to do so by the as far as possible standard in Article 34? Now, again, as Natasha has said, when interpreting the Refugee Convention, we need to draw on broader protections in international human rights and refugee law, in particular in relation to non-discrimination. And here I'm thinking of both the CEDAW general comment that touches on refugee status and barriers to naturalization and indirect discrimination, but I'm also thinking of the Istanbul Convention, which applies in Council of Europe states and puts positive obligations on states to take a gender-sensitive approach to refugee protection and non-refoulement. Now, against the kind of broad structure of the Refugee Convention, we've got something in Europe that people like Jessica Schultz, for example, or Nicholas Faith Tan, who've done a lot of research in this area, characterize as a temporary turn. That whilst UNHCR suggests that residency requirements of between, for example, 2 and 8 years for refugees are appropriate, a number of states are noticing a shift to increasing precarity of status, active status reviews, the large-scale announcements that a particular country is safe and that either refugees should return home or that their status may be subject to revocation if they don't. Jessica Schultz has written a fantastic piece, and there is a broader set of articles in GEMS that you might be interested in this, focusing on Denmark and Norway. The research that I mentioned that I've been involved in earlier has noted that this has expanded across Council of Europe states who are essentially reproducing these precarious and restrictive routes. And this has particular consequences for women. So, and it essentially compounds other forms of gendered inequality in refugee status determination processes. So we know, for example, that women still struggle to be recognized as refugees. As host states introduced kind of ever more types of status, so different forms of subsidiary, complementary, or temporary protection, we see women being funneled into less protective statuses. So not necessarily being recognized as refugees, but protected from refoulement and given a more limited package of rights. That often has implications for someone's ability to naturalize. Status also matters for women because increased precarity and dependency is linked to an increased risk of experiencing gender-based violence and an intensified experience of it, as your status means you're not able to access services such as women's refuges, for example, that national or other women can. Return, when characterized as being, for example, involuntary return or involuntary repatriation, may in fact be just refoulement for women. And as UNHCR has said, and as came out from Natasha's talk, women and girls are particularly at risk, where return would involve a violation of, for example, basic rights, including the right to an education and freedom of movement, in a context where these rights are being systematically eroded. So the racialized nature of the temporary turn in Europe is particularly apparent when we see it being applied to certain nationals or certain groups of nationals, but it's also a term that I would say is gendered. So I'm going to come to an end by talking about new rules in the UK, which kind of exemplify some of these things that we're talking about. So to naturalise in the UK, in general, there's a 5-year residence route, and then there are requirements as to language and integration and good character. New guidance introduced in February this year, however, stated that anybody who made a dangerous and unlawful journey to the UK, so anyone who essentially travelled by boat or who could be criminalised for their unlawful arrival, would be denied access to naturalisation. Now, given the lack of safe and legal routes to the UK, this might be considered a bar on naturalisation, just a straightforward inability to acquire it, and that would certainly be contrary to Article 34. UNHCR and groups of lawyers are litigating this at the moment, but the thing I just want to highlight is the particular impact that this potential bar on naturalisation has on trafficked women, which is a group that Paula Banerjee mentioned in her talk as being particularly vulnerable. because the very thing that makes you a victim of trafficking, that you have been coerced or forced to cross, in this case, an international boundary for the purposes of exploitation, is the thing that, according to this requirement on making an unlawful journey, precludes you from naturalization. So you, at the one hand, recognized as a victim under, for example, Council of Europe and international conventions on trafficking, but on the other hand, you were immediately denied access to the political community that has undertaken legally to assist you. And so what this guidance does is, it's particularly gendered in a number of ways, but it frames being a victim of gender-based violence as a matter of choice and fundamentally of bad character. And I think that's of concern. So I mentioned the report that much of this kind of European research is drawn on. We mapped state practice across the Council of Europe. It's going to be published towards the end of the year. It looks at cessation, naturalization, and voluntary repatriation. And again, I want to thank Catherine Costello and Minos Mouzarakis. The requirements in the UK I have written about in a blog, which goes into more detail about the rules on trafficking and non-discrimination. And in relation to status and violence, I just published a book that looks at European laws on this and the Istanbul Convention. So thank you very much indeed.
Thank you so much, Catherine, for a brilliant presentation and using the UK as a recent example of how naturalization actually can be rejected in a way that disproportionately impacts trafficked women in the example that you gave.